Morning, good afternoon, good evening. Today we'll be talking about money laundering, the legal framework that prohibits it, the societal impact, and the reason for the criminalization of money laundering. What is money laundering? Money laundering is the conversion of property gotten from illegal crime, illegal proceeds, and turning it into a legitimate source. Under the Article 3.1 of the Vienna Convention, they define money laundering as the conversion or transfer of property that they know that the such property is derived from any offense for the purpose of concealing or disguising the illicit origin of the property or assisting any person who is involved in such offense to evade the legal consequences of their action. Before money laundering can happen, there must be a crime. There must be an occurrence of crime. So money laundering is a secondary commission of crime.
And money laundering, it should not be seen as a single act, but as a three-stage process. The essence of this three-stage process is to convert the dirty money to clean money that can be used openly in the economy. The first stage is the placement. Here, the illegally obtained money is being transferred directly into the financial system.
Layering is the second stage of money laundering, and its main purpose is to hide the illegal origin of money. At this stage, criminals try to confuse investigators by moving money through many complex transactions. This makes it very difficult to trace where the money originally came from. They do this by transferring funds between different bank accounts, sometimes in different countries, using shell companies or converting the money into assets like real estate, stocks, or even cryptocurrency. Each movement separates the money further from its criminal source, creating what is called a broken audit trail. In simple terms, layering is like washing dirty money over and over again until it looks clean and untreated.
Integration then happens to be the third and final stage of money laundering. At this stage, illegal or illicit funds have been disguised sufficiently and then are introduced into the legitimate economy to seem as though they appear from legal sources. There are common methods of integration. We have real estate investment. Criminals may purchase houses, apartments, hotels, or buildings, reason being that they are high value transactions, property values may appreciate, and then rental income from these sources may appear to be legitimate. Luxury goods, money may be spent on expensive vehicles, design products, artwork, and jewelry products, and then these products are then in turn sold and converted into money from legitimate sources. It's important for us to know that most money anti-money laundering laws not only target the crime but any other act that aims to conceal, disguise, or try to protect any form of
The
integration.
legal framework of money laundering under the Money Laundering Prevention and Prohibition Act 2022, Section 1 to 5. Section 1 establishes the legal and institutional framework of the Act. It provides a comprehensive system for the prevention, prohibition, detection, investigation, and prosecution and punishment of money laundering and related offences in Nigeria. Section 2. Section 2 provides for the prohibition of money laundering through restrictions on cash transactions. It stipulates that individuals shall not make or receive cash payments exceeding 5 million naira, while a body corporate shall not make or receive cash payments exceeding 10 million naira except through a financial institution. Section 3. Section 3 deals with the reporting of international transfers and movement of funds. It requires that any transfer of funds or security exceeding the 10,000 US dollars or its equivalent must be reported within 1 day to the Nigerian Financial Intelligence Unit, the Central Bank of Nigeria, and the Security and Exchange Commission. While Section 4, Section 1 set out the customer identification and due diligence framework. Financial institutions and designated financial institutions or businesses and professions are required to identify and verify customers and beneficial owners using reliable documents and information. They must conduct customer due diligence when establishing businesses and business relationship, carrying out a large or suspicious transaction, or processing wire transfers. Section 5 finally regulates casinos, including internet and chip-based casinos. It requires casinos to verify the identity of customers involved in financial transactions, maintain accurate and chronological records of these transactions, and forward such records to the Special Control Unit against money laundering. And this record must be preserved for at least 5 years after the last transaction, ensuring accountability and traceability of financial activities within the sector.
Money laundering. The operational enforcement of Nigeria's anti-money laundering framework relies on specific statutory sections backed by powerful judicial precedents. First, mandatory disclosure under Section 11. As seen in Belgo vs. FRN, financial thresholds are strictly enforced. Furthermore, the Court of Appeal in Ago-Iwoye vs. FRN reinforced that professional privileges, including legal confidentiality, cannot mask or shield questionable financial inflows. Second, transparency under Section 12. This section absolutely bans anonymous accounts and shell banks. In Ogbode vs. FRN, the court emphasized that utilizing complex institutional and corporate identities to conceal the true source or placement of funds remained a textbook money laundering violation. Third, shifting burdens under Section 11. In the landmark case of Daudi vs. FRN, the Supreme Court held that where the prosecution proves a defendant's lifestyle or assets are completely disproportionate to their known legitimate income, the burden of proof shifts to the defendant to explain that wealth. The penalties are absolute. Minimum 4 years imprisonment for individuals and automatic business winding up for corporate bodies. Together, these sections and case law ensure that under Nigerian law, there is nowhere left for dirty money to hide.
Money laundering tactics and how the illicit proceeds are being concealed. So with the advancement of financial systems and technology, criminals might employ sophisticated methods such as bank capture, shell companies, round tripping, casino gambling, and soft smurfing to hide the proceeds of unlawful activities. To combat Act of 2022 establishes preventive and punitive measures including customer due diligence, transaction monitoring, mandatory disclosure obligations, institutional compliance requirements, and criminal sanctions. One of the major laundering tactics is bank capture. This is where criminals compromise bank officials, compliance officials to facilitate illicit transactions or suppress suspicious reports. Sections 4, 10, 14, and 15 of the Act address this by requiring financial institutions to verify customers' identity and beneficial owners, file suspicious transactions, maintain anti-money laundering controls, and impose liability on directors or employees who aid money laundering. So the Act also empowers the Nigerian Financial Intelligence Unit, that is NFI, to place suspicious accounts under surveillance. And another common tactic is the use of shell companies, which are entities with little or no genuine business operations used to conceal the true ownership of illicit funds. Sections 4 18 combats these practices by prohibiting shell banks, requiring disclosure of beneficial owners, and criminalizing the concealment, the conversion, or the transaction of proceeds of unlawful activity. Another example of this illicit act is round tripping. This is another laundering method whereby illicit funds are transferred abroad and later reintroduced into Nigeria as legitimate foreign investments or loans. This can be seen in sections 3, 7, and 18, which addresses these by mandating disclosure of cross-border transfers exceeding a US dollar of 10,000, monitoring suspicious transactions, and criminalizing the concealment of unlawful proceeds. Another example we have is casinos. Casinos have also historically been used for money laundering over the years, particularly at the placement stage, where criminals exchange the dirty cash for gambling, for chips, and later cash them out as cool and supposed winnings. Section 5 provides for this, and it requires that casinos, including online casinos like this bet sites, to verify the customer's identity and maintain a detailed transaction result and forward such results to the CUML, that is the body that has been brought up against money laundering.
Why is money laundering illegal? Money laundering is illegal because it poses a fundamental threat to our legal order as it allows criminals to profit from crimes with impunity while concealing the predicate offenses like drug trafficking, embezzlement, extortion, and other crimes, which is the actual source of the money. Why do we criminalize money laundering? Money laundering is criminalized in order to protect financial systems like our banks and other financial institutions. Money laundering is also criminalized in order to stabilize the economy, as it can distort markets and also give criminals access to large sectors of the economy. We also criminalize money laundering in order to ensure criminals do not profit from their crimes by means of ordering forfeiture of laundered assets. Now, according to the Financial Action Task Force, money laundering allows criminals to infiltrate financial institutions, have control of economic sectors, and also control public officials and departments.
Conclusion. With the above listed facts and scenario and societal impact, money laundering is one of the dangers to our society, and it has been criminalized and prohibited in the Nigerian state. Thank you.